My name is Donald Trump. I am the former President of the United States. The Colorado Supreme Court ordered my name to be removed from Colorado's presidential primary ballot because I am allegedly disqualified from being president under Section 3 of the 14th Amendment, which states, "No person shall hold any office, civil or military, under the United States, who, having previously taken an oath as an officer of the United States to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same." But Congress may, by a vote of 2/3 of each house, remove such disability. It is argued that I am disqualified from office because I engaged in insurrection during the storming of the Capitol on January 6, 2021. However, Section 3 can only be enforced by congressional legislation, not by states such as Colorado, because state trial courts should not be able to undemocratically decide who is eligible to run for a national office as important as the president.
My name is Norma Anderson. I am a Republican voter in the state of Colorado, and I want you removed from the ballot because you are disqualified from office under Section 3. Those states cannot create their own qualifications for presidential candidates. Their broad authority to regulate elections allows them to exclude candidates who do not meet constitutional eligibility requirements, such as age, residency, and natural-born citizenship. Using this power, states can also exclude someone like you who has broken their oath to support the Constitution by engaging in insurrection.
We'll see about that.
The Supreme Court delivered a heavy blow to special counsel Jack Smith's election interference case against former President Donald Trump, ruling along partisan lines that Trump has broad immunity for acts taken while he was in office.
This will be referred to from now on as a landmark opinion of the Supreme Court. It's not only important for President Trump's criminal case, they really have set a framework for all future presidents.
In August 2023, a federal grand jury indicted Trump in an unprecedented criminal case, charging the former president with 4 crimes related to his alleged attempts to overturn the 2020 election.
Donald Trump's defense team puts forward this argument that a former president should be held completely immune from prosecution for any of the acts that they performed while in office.
I feel that as a president, you have to have immunity. Very simple.
After a lower court rejected Trump's immunity claims, the former president appealed, and on July 1st, the Supreme Court gave him a sweeping amount of protection against criminal prosecution.
The court's very explicit about this. It lays out its framework by saying, quote, "The nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority." What the court is saying in this part is quite surprising. They're basically saying that nothing he does in terms of pressuring the Justice Department to investigate whoever he wants to investigate as president can ever be subject to criminal liability.
So friends, given how today's oral arguments played out in the Supreme Court, on the issue of whether somebody who engaged in insurrection should be allowed to hold office again in the future, given how those arguments unfolded, today was a rough day. It was a rough day for the rule of law. It was a rough day for the sanctity of our vote. It was a rough day for justice.
Laura, what do we know right now?
A really consequential decision has just been handed down. Paula Reed, the court has made a decision.
This is a win for former President Trump. Here, the Supreme Court has reversed a ruling from the Colorado Supreme Court that would have removed former President Trump from the ballot under Section 3 of the 14th Amendment.
In Trump versus United States, we explore the intersection of presidential immunity and criminal liability. In 2023, a federal grand jury indicted former President Donald Trump for purported criminal conduct occurring in office. The indictment alleged that after losing the November 2020 election, Trump conspired to overturn the result by making knowingly false claims of election fraud. Specifically, the indictment claimed that Trump encouraged the Justice Department to conduct sham investigations and alert state officials of suspected fraud to replace legitimate electors with Trump's preferred electors, tried to convince the vice president to use his ceremonial role at the January 6 certification proceeding to reject legitimate electoral votes, tried to convince state officials, private parties, and the public that election fraud tainted the vote, and used tweets and a January 6th speech to encourage supporters to go to the Capitol building to pressure the vice president during certification. Trump moved to dismiss the indictment, arguing that a former president has absolute immunity from criminal prosecution. The district court disagreed and denied Trump's motion. The Court of Appeals affirmed, and the United States Supreme Court granted cert.
The High Court's opinion also says that Trump is entitled at a minimum to presumptive immunity from prosecution for all his official acts. However, a court could determine that some conduct, such as a campaign speech or fundraising, constitutes an unofficial act.
The Supreme Court says, quote, the president enjoys no immunity for his unofficial acts, and not everything the president does is official, end quote. So a big question here is, when was President Trump acting in his official capacity as President of the United States versus when was he acting as candidate for re-election?
We will never concede. It doesn't happen. You don't concede when there's theft involved.
When President Trump gives his speech at the Ellipse on January 6th and suggests to his supporters to go to the Capitol, is he speaking as political candidate or is he speaking as president? The majority opinion doesn't tell us which. They give the lower courts some quote-unquote guidance, but that will be a key determination as to whether that can even be part of the allegations, even part of the evidence that could be used at trial.
The court's 3 liberal justices could barely contain their outrage. The dissenters said the majority opinion makes a mockery of the principle foundational to our Constitution and system of government, that no man is above the law. Having won from the court nearly everything he could have hoped for, Trump celebrated in a Truth Social post, writing, "Big win for our Constitution and democracy." President Biden called the court's decision a terrible disservice to the people of this nation.
Today's decision almost certainly means that there are virtually no limits on what a president can do. This is a fundamentally new principle, and it's a dangerous precedent.
The ruling sends the case back to federal district judge Tanya Chutkan in Washington.
The next step is for Judge Chutkan to engage in what we call fact-finding. She will now apply the Supreme Court's framework to the allegations to determine what is official versus unofficial conduct. If it is official conduct, is it absolutely immune? If it's not absolutely immune, is it presumptively immune? And if it's presumptively immune, could the government rebut the presumption? That's all a hodgepodge of very difficult legal questions. I think it's inconceivable that there will be a criminal trial before the election.
If Trump is elected to a second term, experts say he has several options to quash the case.
President Trump would be the head of the executive branch of the Justice Department. He could order the Justice Department just to stand down.
All right, good morning. It is Saturday, September the 13th. I'm Ali Velshi. If you happen to have your pocket Constitution with you, it's going to become very useful in the next few minutes. This week, the Supreme Court gave federal agents the green light to geographically, racially, linguistically profile people in the course of immigration sweeps in Los Angeles. Now, in doing so, it shattered one of the bedrocks of the American legal tradition. My goal today is to leave you with a clear understanding of just how grave this Supreme Court decision is. The Fourth Amendment to the U.S. Constitution begins with these words. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The right of the people to be secure in their persons. Few parts of the Bill of Rights drew more directly from the lived experiences of Americans at the time than this one. American colonists lived under a British crown that tried to police their private lives, their communications, and their gatherings.
And discussion for years. And there's no question that it would be legitimate were Congress to eliminate the capacity for the lower federal courts to issue nationwide injunctions. But just like with the unitary executive theory, it is clear to the world, because the president and now Senator Grassley have made clear to the world, that the only reason that they're pursuing these limitations on the federal courts is because the federal courts have ruled against the president and his administration. So just like with respect to the unitary executive theory, in my view, this would be the worst moment possible to eliminate the nationwide injunction, because today, in this moment, because it's the president that is politicizing the courts and the law, it's not the courts that are politicizing the courts and the law, it's the President of the United States.
What it means, Ali, is that the Supreme Court has made it much easier, not only for this president, but for any president, to get away with violating any law, including the Constitution. The example of a hyper-liberal president ordering that agencies of the federal government take away everybody's gun or restrict religious exercise of a kind that doesn't satisfy the views of the majority, those kinds of examples, too, would be subject to this entirely new regime. It's a regime that is completely inimical to the rule of law. In a nation of 300 million people, you can't possibly say that when the Constitution or a federal statute is clearly and outrageously violated, they get to keep violating it unless and until everybody has sued or someone representing everybody in a cumbersome process has achieved standing to sue, unless and until the U.S. Supreme Court speaks.